Yeah, I would be more sympathetic to a deferential review if we were dealing with something where like everyone agreed the attorneys did something wrong, and then the court was just deciding, is this bad enough for sanctions or something?
Right. Yeah, it does seem also, and I bet these attorneys knew they were getting into this, but that this particular lawsuit, I haven't read the complaint, but from what these opinions say, this particular lawsuit, it kind of maybe push the envelope a little bit with this insecurity about elections. And one reading of it, I guess, is that they're saying something that it seems like would be ridiculous for them to say because everyone knows it's not true about paper ballots. But there were, of course, a lot of election lawsuits around the same time. How crazy and disingenuous does your lawsuit need to be before the court sanctions you and makes you pay the other side's legal fees? We look at the Ninth Circuit's thoughts on that delicate question. And we also dig into the Constitution of the National Football League. The Second Circuit called unsportsmanlike conduct on that revered document. For good reason, it seems. All that this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, August 27th, 2025, and I have two of my IJ colleagues here to bring you the latest from the Federal Courts of Appeals. They are Mike Greenberg and Jeff Redfern. So Mike is going to be bringing you the first case, which is this case about the NFL and its constitution and a lawsuit with a former coach of some of the teams and a current coach with another team. The controversy is something you've probably heard about in the news in the last couple years. It involves Brian Flores, who is currently a coach with the Vikings, who is suing the NFL itself and some other teams for racial discrimination. But the opinion from the Second Circuit really has little to do with that underlying fact, but it has a lot to do with how the NFL tries to send people to arbitration. Then later on, Jeff is going to get at this matter from out west in the Ninth Circuit about fining lawyers for bringing claims and where the line is when a court fines a lawyer for bringing something that is frivolous or untrue or whatever. How do you decide that? Now, we'll get to Mike in a moment with the NFL case, but first we're going to go to Jeff because Jeff was telling me when he was in big law before he was working at IJ, he did a lot of work, as anyone in big law and litigation does these days, about arbitration. And so, Jeff, maybe for people who aren't lawyers or haven't luckily been inside civil litigation much recently, how big a deal is arbitration to big companies like the NFL?
It's a huge deal, Anthony. And one of the issues that we were litigating was the statute called the Federal Arbitration Act. And the gist of it is that it says that contracts to arbitrate a dispute, so these can be contracts that happen before a dispute arises. Like, let's say you and I start a business agreement and we say, look, if we have any issues about this, we'll go before a private arbitrator and they'll settle it. We won't have to spend all this money on legal fees and the complexity of federal court litigation. You can also obviously agree after the fact when we're already in a dispute, say, hey, let's settle this the cheap way. So this has been very controversial, and a lot of states over the years have had doctrines that have in various ways disfavored arbitration. So the Federal Arbitration Act basically says that arbitration agreements are supposed to be enforceable the same way any other contract is. And that has spawned lots and lots of litigation as states have said that particular arbitration agreements aren't enforceable, and the Supreme Court has repeatedly said, yes, they are. Now, some of that litigation, I think, has finally calmed down. It seemed like a lot of the issues are really settled at this point. But it was a huge part of my practice when I was just starting off. It was mostly compelling the enforcement of arbitration agreements. And oftentimes these were immediately appealed as interlocutory appeals. So it kept us quite busy.
Yes, and that is an aspect of the case that we're going to talk about today. Now, luckily here at IJ, when we sue the government, the Constitution itself doesn't have an arbitration clause. So, I mean, we can't sue for other reasons that we talk about all the time here on the show, such as qualified immunity or whatever. But your chance to get in federal court and not get shunted to an arbitrator is pretty guaranteed. However, when you have an employment contract with an NFL team, things can be a little different. And so, Mike, tell us the story of now assistant coach Flores, but he used to be head coach Flores, and the National Football League.
That's right. Yeah. So as you were just saying, Anthony, a lot of the times we are required by the Constitution to get into federal court. But this case is kind of timely and rhymes with a lot of IJ's constitutional fights to actually get into federal court. It's got similar characteristics to the Third Circuit case litigated by IJ that you discussed on the show a few weeks ago with our colleague Rob Fellner. It prompted you to quote from Gary Lawson's seminal law review article about how in the administrative state, everything is done by the commission.
Right.
The prosecution, the adjudication, the appeal. This case's theme is not all that dissimilar from that. You just have to change the word commission to commissioner. The case caption is Flores versus New York Football Giants, Inc. I love New York Football Giants.
Yeah, they still call themselves New York Football Giants.
As distinct from the no longer operational New York Baseball Giants. Other NFL teams and the NFL itself are also defendants. It was decided August 14th in an opinion by Judge Cabranes and joined by Judge Lynch and Judge Lohier. And as you've said, the lead plaintiff is Brian Flores. He's a longtime coach across the NFL for several teams. He's currently the defensive coordinator for the Minnesota Vikings, and a pretty good one at that. He's also coached with the New England Patriots, the Pittsburgh Steelers, and was the head coach of the Miami Dolphins for a while. And the actual claims in this case only get mentioned in a footnote, so you might miss it if you blink. They arise from this practice that the NFL has that's called the Rooney Rule, which has strong intentions but has led to a lot of messiness in practice. It requires that NFL teams, when they have certain coaching vacancies, they have to interview two people who are members of minority groups. Unfortunately, what this sometimes yields is that teams have their mind made up already on who they're going to hire, but they still have to satisfy the rule, and that's led to unfortunate stories of teams kind of announcing that they've hired the candidate that everyone knew they were always going to hire, like 5 seconds after the second minority interview leaves the building. Or you have among Brian Flores' allegations that when he was interviewing for the head coaching job of the Denver Broncos, the head of the Broncos football operations department, Hall of Famer John Elway, shows up completely disheveled, an hour late, and seemingly hungover. In other words, a sham. So this case, though, is not about any of that, or whether Flores and his co-plaintiffs are correct that the team and the league in some of their practices are violating the anti-discrimination provisions of 42 U.S.C. Section 1981, right next to our beloved Section 1983. This case, as we've said, is about arbitration and whether the allegations need to be handled in an arbitration proceeding, this kind of more informal, private matter or manner of adjudication.
Right, because like the Supreme Court has said, kind of cases that Jeff was talking about, there's all kinds of things that even if federal law requires your employer to do it, that you can have arbitration. So like a lot of people know about Title VII, where private employers cannot discriminate on certain bases like race or religion on their employees. And so if you have a Title VII case, that can have to go to arbitration, even though, you know, it's a federal law.
if you contract for it, and
Right.
as we'll see, if it's the kind of contract that the Federal Arbitration Act is willing to or contemplates enforcement. Flores wants to continue to proceed in the Southern District of New York, and the NFL and its teams who are defendants want to have this move to arbitration. And so they file a motion to compel arbitration, which is granted in part. And that prompted the defendants to appeal insofar as the motions to compel arbitration weren't granted in full. The Second Circuit in this case is going to affirm. So some backdrop here. There are two different arbitration clauses at issue. The first one is, or they're both in every coach's employment agreement with the team that they're employed with. That employment agreement has a first arbitration clause, which is a team-specific arbitration agreement. They agree to arbitrate claims against that particular team. The employment contract also incorporates, by reference, the NFL Constitution. So as you pointed out, Anthony, this is a constitutional case. And the NFL Constitution grants the NFL commissioner, quote, full, complete, and final jurisdiction and authority to arbitrate any dispute between any coach and any member club or clubs. So that's incorporated into the contract. And so the question in this case is going to be is whether that's enforceable. Just in case it's not clear, the NFL commissioner is selected by the team owners. And the team owners are effectively his boss. He is who the association's members have appointed to kind of run their little trust that they have, and they pay his salary. So you can see perhaps where this is going. The appeal doesn't concern any of the team-specific arbitration agreements. Basically, those would come into play when the coach is seeking a higher status position with a team that already employs them. They want to move from, assistant coach to head coach or something like that. Those agreements, the district court holds, are governed by the plain language. There's no enforceability problems. This appeal doesn't concern them. This is about the second clause that governs when your beef is with a team that you're not under contract with. Just for the mechanics of it, when Flores was an assistant coach with the Patriots, he had that sloppy interview allegedly with the Denver Broncos, and he has a claim about that. After the Broncos' alleged debacle, he is hired by the Dolphins. After a few years, the Dolphins let him go. And then he has a few interviews for subsequent coaching opportunities with the Giants and with the Houston Texans. And his final two claims are arising from his not getting those jobs. After those interviews, he's hired as an assistant coach with the Pittsburgh Steelers, and he signs an employment agreement that is basically the same as his one with the Patriots. And so the issue is whether that incorporated second clause that requires the commissioner to arbitrate all disputes between coach and team is actually enforceable. And the Second Circuit's analysis on that question starts with some broad principles of the Federal Arbitration Act. As Jeff was saying, it's a statute that has a pretty broad general policy in favor of enforcing arbitration agreements. If the parties enter into such an agreement, it's a contract, and the courts are generally inclined to enforce contracts as they're written. But the Second Circuit goes on to point out the flip side of that is that the Federal Arbitration Act only covers agreements to arbitrate. The court doesn't have to enforce a contract to settle a dispute by other means that are not arbitration. The examples the court uses are duels or games of ping pong, because that is not what the Federal Arbitration Act contemplates.
So, but you could have a contract that says, a game of ping pong will settle disputes, but you could put it in a contract. Whether or not it's enforceable is not a question of the FAA. So the FAA doesn't help you go to that game of ping pong because it's not arbitration. But separately, maybe it's enforceable, maybe not. That's just not a question under the FAA, right?
Right. And Jeff can correct me if I'm wrong. I imagine that would be like a state contract law question rather than a question for the FAA itself.
Yeah, that's right. And normally it doesn't come into play because the states are always coming up with state contract reasons not to enforce an arbitration agreement, and then you're saying the FAA trumps it. But if you say the FAA doesn't apply, you still have this next step. Is this an enforceable agreement under state law?
Yep. And not to muddy the water a little bit, but that's kind of what the district court did here. Is the district court kind of reached for state law reasons not to enforce these contracts. The Second Circuit isn't going to do that. It's going to say that this doesn't even satisfy the FAA. But yeah, so the FAA only contemplates agreements to arbitrate. And that means that the dispute resolution agreement actually has to resemble what the FAA contemplates as quote-unquote arbitration in order for it to be enforced. And then separately, kind of along similar lines, the Second Circuit talks about how there's this doctrine that holds that when statutory rights are at stake, as here, arbitration requires that there be an effective forum to actually vindicate those statutory rights. These two things kind of rhyme. Like if it doesn't look like arbitration, then it probably isn't effective to validate your statutory rights. Like a game of ping pong doesn't really do that. But that's broadly our legal backdrop. And against that backdrop, the Second Circuit provides the answer: no, the FAA doesn't require Flores to enforce the second arbitration clause. Doesn't require him to arbitrate his claims that are not covered by the team-specific arbitration agreement in front of the commissioner himself. And the reasons are both because the process doesn't look like arbitration, and relatedly, it wouldn't give him a sufficient opportunity to vindicate his statutory rights. In explaining that, the court says, look, arbitration, we get it. It's generally more informal. It's a private, non-judge adjudicating these things. The parties can kind of model different procedural rules that are different from what you might ordinarily get in court. But one thing that arbitration absolutely has to have is some modicum of independence from the parties. The dispute, the person resolving the dispute has to be at least seem to be independent. And the process also has to have some clear rules that are, apparent upfront and enforceable. And this process that the NFL here is contemplating is neither. The commissioner himself, who would be the adjudicator, is not independent at all. He is just, he's a party to the case. He is the head of one of the entities that Flores is suing. And as for the other defendants, the teams, he receives his salary from the owners of the teams that Flores is suing. That's just not submitting the claim to an independent forum in any kind. And secondly, there are no procedural rules, the court points out, governing the arbitration process here, which is another thing that arbitration requires. In fact, as far as there are rules, the court says the rule is that the commissioner gets to make the rules up as he goes, kind of. So it just doesn't look like arbitration as contemplated in the Federal Arbitration Act.
It would be like if I buy a Tesla and have a dispute with Tesla and I sue, and then the contract says Elon Musk gets to decide who wins, and he also gets to make up the rules like as we go forward. That would not be covered by the FAA.
It just to say it out loud is to kind of doom the claim. After the briefing in this case was closed, the NFL tried to tell the Second Circuit that actually it's not the commissioner himself who would be the arbitrator here. In addition to the power to just arbitrate himself, the NFL Constitution also grants him the authority to just delegate somebody else that he wants. And so in this case, the commissioner, the Second Circuit is told, has exercised his authority to appoint someone to stand in his stead as the arbitrator. And the court's opinion goes on to say, well, that doesn't really solve anything either, because the guy that you're talking about, he serves on some NFL committees. He's worked as a contractor for the NFL, or a consultant for the NFL before. So it doesn't really help you all that much on independence just as a factual matter. But also because you appointed this person unilaterally, that only underscores the lack of independence, that the other party has no say or this is just not an independent person at all. And it certainly doesn't solve the problem of the lack of rules or procedures inherent in the process. Those same flaws ultimately support the related ground for not enforcing this arbitration clause, which is that it fails to provide a forum to vindicate Flores' statutory rights. If it's inherently unfair, or I think the language the court uses is, quote, inherently biased, then it just is not a proper place to vindicate important statutory rights. And for those reasons, the court refuses to enforce it under the FAA.
Jeff, did you ever work on a juicy case like this in your arbitration days where the arbitration was the boss of one side?
I can't recall anything like this. In fact, our approach was always, even when we were just consulting in crafting these agreements, to make them as pro-consumer as possible so that there was no possible argument that this wasn't a fair procedure. Because typically, the plaintiff's attorneys wanted to get class actions, and the defendants just wanted to avoid class actions. They didn't really care if individual consumers won every one of these claims, which they actually tend to do in consumer arbitration before like AAA. Consumers tend to do very, very well if they actually bother to file the complaint and explain their side of the story.
Yeah, that's what I've heard is when it gets down to actual arbitration, at least consumer arbitration, you can often win, but the companies are, I guess, fine with that trade-off because then you're not going to get these massive class actions.
And the argument on the other side is, yes, the class members may not be getting that much relief in a class action, but it deters misconduct, whereas the individual arbitrations don't. So those are basically the policy arguments.
Right. What it seems like, Mike, what it seems like maybe happened here is I was really struck by the use of the NFL Constitution, then by reference being in all these agreements, and it reminded me of in labor law this often happens where you'll have like a union agreement at one level and then that union agreement incorporates like some other agreement that some other group of employers and a bigger part like section of the union is worked out somewhere else, and the people entering into this have no idea about what these like bigger documents are, but they're just incorporated by reference. And so by incorporating this Constitution by reference in these employment agreements, this wacky thing in the Constitution, which I'm guessing was more for like teams suing each other and then the commissioner, adjudicating between them, which actually kind of makes sense, then getting shoehorned into this kind of more just it's not run of the mill exactly, but like employment dispute that's really nothing to do with what that original purpose was.
Yeah, it seems certainly more appropriate that the commissioner has like final authority over like things that are going on the field, or like discipline for like on-field conduct maybe, or something like that. But it just seems kind of insane that the commissioner of this private organization can be the one to adjudicate whether this like long-standing federal anti-discrimination law was violated by private parties. And I'm sure this is true in a lot of other consumer contexts also, but the NFL is a little unique in the sense that like you can't negotiate around this. Like this is a forum contract. Like there's only 32 employers in this tiny little club that they have. This is probably not the case if you're like agreeing to arbitrate, an issue with like a cell phone that you purchase. Like I'm sure AT&T and Verizon equally have the same, consumer mandate or arbitration mandated process as well. But like this is it's one employer and they're not budging on this whatsoever.
I have one nuanced question that I'm confused by, and I think both of you are much smarter about this subject than me, so maybe you can help. And it kind of goes back to what we were saying earlier. But basically, the court says the Federal Arbitration Act does not apply because this is not what is considered arbitration under the Act. And then it goes on to say that the clause is unenforceable, but it doesn't really tie it to Massachusetts law of all things, because this case was filed in Massachusetts. So I didn't really get why it's unenforceable. And Jeff, you were talking about, how all these states have this anti-arbitration stuff themselves. Is that just that the court kind of didn't spell out the details there, or what am I missing?
I was confused as well. I thought, okay, the FAA doesn't apply. Now we're going to get into the state law. And usually this effective vindication stuff is coming in as another argument. It's coming in on the other side. I've never seen it sort of as a standalone way of invalidating something that would otherwise be enforceable under state law. Usually you would go to state law first. And if something isn't arbitration under the FAA like this, I assume that most states would also say it's not enforceable under their own contract principles.
Right.
But I think this maybe is just an example of federal courts not wanting to do the work of figuring out what state contract law is.
And the district court was very excited to do that. The district court held on Massachusetts state law grounds that this was not enforceable, and I think under Pennsylvania law for the other contract, and the Second Circuit just, no, across the board, this is not enforceable as a matter of federal law. I wonder if maybe the state court decision, the district court's decision on state law wasn't appealed, and this was only the federal. I'm not sure exactly procedurally what happened there, but perhaps you're right that it's just an assumption that if it's not federally enforceable, then it's definitely not state enforceable.
You almost get a sense of it's like kind of federal common law, that you just can't have a clause like this. It's a little bit of a pre-Erie doctrine kind of natural feel that crept in, but who knows? Maybe the court just didn't think that deeply about it. We're going to arbitrate our way out west now to the Ninth Circuit and to some controversies that are not going to be unfamiliar to our listeners about alleged election shenanigans in Arizona. And the thing is that the case that Jeff's about to tell folks about, it isn't about some of the more crazy, you might say, stuff that has gone on in Arizona with elections. I think the lawyers here were more careful about what they were trying to do than has happened in other instances, and yet they still got in some trouble. So, Jeff, tell us about that trouble.
Sure. So this case is Lake v. Gates, and the opinion I'm also going to be talking about is a Ninth Circuit dissent from denial of rehearing and banc, sometimes known as a dissental. I don't know if Short Circuit has an editorial policy about the use of that word, Anthony.
We've kind of gone back and forth. I got to say I frown upon it, but it is a useful word. So
it's useful, and it's a little ugly, but what are you going to do? So this was a dissental by Judge Van Dyke, joined by 5 other judges. Now, the underlying lawsuit was filed by Kari Lake, then a candidate for Arizona governor, in 2022. Now, this was a pre-election lawsuit, so there were plenty of other cases challenging the outcome of that after she lost. This is one where she was trying to get a preliminary injunction to change the way that Arizona counted votes. And she alleged that Arizona's system was vulnerable to hacking, particularly with the way that computers were used to count ballots. Now, she tried to get a preliminary injunction. She failed. And then the case was dismissed for lack of standing after the election. Now, standing, it's hard to challenge election procedures because of standing. So even if you're correct on the merits and there is something illegal and states are not following their own law, in federal court in particular, you have to show that you have some kind of individualized injury. And normally, an interest in having the law followed and an interest in good government procedures is not the kind of individualized injury that's going to give you standing to go into court. And any allegation that the machines were going to get hacked and then I was going to lose the election is far-fetched enough that's usually not going to work either. So she lost on standing ground, and that was affirmed unanimously by a Ninth Circuit panel. But what's interesting to me is what happened next. The district court sanctioned Lake's attorneys under both Rule 11 of the Federal Rules of Civil Procedure and a federal statute, and ordered the attorneys to pay the defendant's attorney's fees over $120,000. And the ground here was that the attorneys had filed a complaint that was both factually baseless and that they failed to make a reasonable inquiry into the facts before filing it, and also that in doing so they acted in bad faith. So the district court kind of zeroed in on a few issues in the complaint. It said that the complaint falsely stated that Arizona does not use paper ballots and that it was asking for the use of paper ballots, but Arizona's already doing that. So what exactly are they asking for here? And it also, the district court also said that the complaint falsely stated that the vote counting software hadn't been objectively and neutrally validated, when in fact, the state had validated this software. Well, what the attorneys here for Lake said was that, look, if you read our complaint in the light most favorable to us, which you're supposed to do when you're both evaluating a complaint under a motion to dismiss standard and certainly when you're looking at sanctioning attorneys. What we were saying is that a safe election procedure is one where you use paper ballots and then you count them by hand. Now, we didn't say that Arizona doesn't use paper ballots. In fact, everyone knows that Arizona uses paper ballots. The problem is that after you cast a paper ballot, they get fed into a machine that counts them, and then they get tabulated by computer. And it's this backside, the counting side of the voting, that is subject to manipulation and to hacking. And as for the software being validated, we never said that it hadn't been validated at all. We said that it hadn't been objectively and neutrally validated. We want a third party to do it. We don't want the defendant in this case to do it and just promise that it's good enough. Now, whether these allegations are true, as the plaintiffs characterize them, nobody knows because this was dismissed on the pleadings. So there's no discovery. There's no record in this case. We don't know if these machines are susceptible to manipulation or hacking. My suspicion is that probably they are not, and that probably this is perfectly valid software. But we don't have any sort of a record on this. So the district court basically, at least according to the dissental here, read this complaint uncharitably. It basically read it against the plaintiffs and said, well, it's true, you didn't specifically state that Arizona doesn't use paper ballots, but that was implied, and that implication was reckless, and it wasn't true, so we can sanction you for that. And your insistence on objective and neutral validation of this software ignores the fact that Arizona itself has already, checked this software out. The dissental says, look, this is clearly a long shot case, but long shot cases happen all the time, and you can't get sanctioned for a long shot case. You also can't get sanctioned for the implications of your complaint. You can get sanctioned for making knowingly false statements, but the district court wasn't able to identify anything in the complaint that was objectively knowingly false. It was all, as the dissental put it, penumbras and implications. And another issue that the dissental flagged was that the district court said it's issuing these sanctions to send a message to people who would undermine faith in our elections. And this was a pretty controversial issue at oral argument here. And I'm of two minds here, because it's clearly the purpose of sanctions to deter the filing of frivolous lawsuits and to deter attorneys from filing lawsuits where they make knowingly false statements or they recklessly didn't investigate the facts. But it seems like the district court was saying that I'm also applying sanctions here because I don't want to have these types of election related cases filed at all. That these are just bad cases regardless of whether they are objectively meritless. So it sort of depends on how you read what the judge was saying there. But if you hold that up against the fact that it also identified false statements that were not actually false in the complaint, it does seem like this is a problematic sanctions decision. And it's interesting to me for a few reasons. Mostly personally, because I'm a strategic constitutional litigator, and we often file cases that at least some people think are so-called Hail Mary passes or real long shots. Of course, we think that we have a very strong basis for all the cases that we file, but sometimes, particularly when we're trying out a new theory, judges just really hate our theories, and they'll write very harsh opinions. But then a few years down the road, other judges write opinions that vindicate us. And I think that there's a real risk that sanctioning attorneys for filing frivolous cases could deter this kind of litigation, this kind of strategic sort of we're going to move the law litigation, unless you keep the bar very, very high, which is what the Supreme Court has said over and over is supposed to be the standard. But today's crazy theory can become tomorrow's settled law. That's how we got Brown v. Board. It's how we got Roe v. Wade and how we got Dobbs. So litigants are allowed to take long shots. And to be clear, I'm not expressing any sympathy for the specific legal claims in this election case. It's just that I think what the district court was identifying just didn't meet the standards here for sanctionable conduct.
And that is, it seems, why the district court also fell on this alleged fact, the facts that were not true that it claims were in the complaint. But then, because it's not really a charitable reading of the complaint, is that they didn't actually do that. That really does seem to make a problem in my mind. Mike, did you have a similar read?
Yeah, there are two things that kind of stood out to me here. One is largely agreeing with what Jeff said. Like I have no significant sympathy for the kind of election-related litigation that we've seen in the last couple of years, personally speaking, at least, or even calling into question on kind of abstract or not particularly strong grounds the way that elections are run. But I'm also a kind of constitutional move the law in the right direction lawyer, and the idea that the district court was singling out particular subject matter of lawsuits as this needs to be an example that is set really did not rub me the right way, because you never know what district judge is going to have kind of the wrong box that you click in Minesweeper, that they don't like that kind of litigation, and who knows, it could be hours and on any given day or with any given judge. The other thing that stood out to me in this case was everyone seems to agree that the standard that the Ninth Circuit is reviewing this under, the propriety of the sanctions order, is abuse of discretion. And there are a lot of things that circuit courts review the trial courts doing under an abuse of discretion standard. And I don't have deep thoughts as to whether a sanctions order overall is something that should be reviewed under that standard. But here, it seems kind of inapt in this case where like we're talking about like reviewing how to interpret allegations in the complaint, right? Like abuse of discretion makes perfect sense when the trial court is there listening to testimony and like evaluating credibility. As I read it, none of that really was going on in this case. This is just about like how charitably are we going to read these paper documents that were submitted by these attorneys to the court. That seems like something that should maybe get a little more independent review from the circuit court rather than just kind of, well, it's not totally horribly awfully wrong, so we have to let it stand.
Yeah, and it almost seems like the abuse of discretion standard here should almost be canceled out by the rule that we read the complaint charitably towards these attorneys. I would be more sympathetic to a deferential review if we were dealing with something where like everyone agreed the attorneys did something wrong, and then the court was just deciding, is this bad enough for sanctions or something?
Right.
Yeah, it does seem also, and I bet these attorneys knew they were getting into this, but that this particular lawsuit, I haven't read the complaint, but from what these opinions say, this particular lawsuit, it kind of maybe push the envelope a little bit with this insecurity about elections. And one reading of it, I guess, is that they're saying something that it seems like would be ridiculous for them to say because everyone knows it's not true about paper ballots. But there were, of course, a lot of election lawsuits around the same time about like the Vatican controls the vote boxes and, you know, the smart tech and all those, whatever those companies are called that had all those defamation claims, right? There was all that other stuff going on. And so then this little strategic lawsuit in the wake of that was in some very choppy waters. And that does not excuse, I think, what the district court or the Ninth Circuit did. But I'm guessing if this lawsuit had been filed, say, in like 2005, and we hadn't gone through all that stuff, it probably would have been a different result, right?
Yeah, I think that's right. I also think there's a difficulty in some of these sanctions cases where if a case is really weak and like kind of crazy and far out there, it's almost certainly going to get dismissed on the pleadings before there's any discovery. But then when it comes time to discuss the sanctions, like you don't have a record. So it's hard for courts to say objectively, I'm going to sanction you because you lied, and we know for a fact that's true. You might know in the back of your head, like the way people with common sense know, like the Vatican is not controlling our elections or something like that. But it's hard in a court of law with due process to say, we know you lied and we're going to make you pay $100,000 when those allegations have never actually been tested. So I think what happens sometimes is that courts are thinking, look, this is a totally crazy lawsuit, but I've got to find something on the papers that I can use to deter it because I don't have a record to show that what they're alleging isn't true. Right. I think what's ironic about this case is that it turns out the Arizona bar actually had disciplinary hearings about this case and about these exact allegations. And they had a 3-day evidentiary hearing and concluded that the plaintiffs hadn't done anything wrong. So, it's not a court, but they had a record and the court didn't. And on the record, Arizona thought there wasn't anything wrong with this.
And on the subject, so the separate subject of pushing the envelope on existing law, maybe many listeners probably know, but many of you don't, that IJ does this all the time. That there's a case. I mean, you mentioned like Dobbs as a prototypical example, Jeff, but in IJ's own cases, we file complaints all the time where we'll have count whatever, and then we'll have a little footnote saying we know this is foreclosed by the following case, but we're filing it anyway in good faith. Attempt to I forget the exact phrase, but revise existing law or whatever it is. And that often is in our privileges or immunities claims of section 1 of the 14th Amendment, where the slaughterhouse cases in 1873 made that not a great vehicle to vindicate the right to earn a living, but we are committed to overturning that case. And so we filed all these complaints where there's a little footnote saying, yeah, we know about slaughterhouse. we're just asking for that to be overturned eventually, and then we usually have that case, that count dismissed early in litigation. We go on with our other claims, and on it goes. So we will continue filing those complaints that ask for Slaughterhouse to be reversed.
I think a lot about our tour guide cases. When I think about this issue, that one of our first cases in New Orleans, where we were arguing that this tour guide licensing scheme violated the First Amendment, the court, it didn't just reject it; it found the theory like baffling. The opinion basically said, like, what are you guys thinking? This has no impact on speech whatsoever. But it was only a few years later we had a similar case, legally identical, in the D.C. Circuit, where the court said this is egregiously unconstitutional, and it probably would fail rational basis review, but it's First Amendment, so it definitely fails any heightened level of scrutiny. I think that under these sort of relaxed standards for sanctions, maybe we would have gotten sanctioned in the Fifth Circuit for that. But it turns out that we were right, because we have since won all of those cases.
Yeah, and the Supreme Court in other litigations basically said we were right.
Yep.
So, well, thank you guys for both being right about your cases today. Thank you, everyone, for watching and listening. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.